SJC-12798, Mark R. Thompson, and another v. JPMorgan Chase Bank, N.A.
Mr. Schoenfield, good morning.
Morning, Your Honor. Mr. Chief Justice, and may it please the Court. As this Court explained in Pinty, in order to exercise the power of sale and non-judicially foreclose, a lender must strictly comply with the notice requirements of paragraph 22 in the standard GSE mortgage. Paragraph 22 requires a lender to notify a borrower in default that she has the right to reinstate her loan after acceleration. Chase did that here. It told the Thompsons, using the precise words of paragraph 22, that they had the right to reinstate the loan after acceleration. Chase provided accurate notice required by paragraph 22, and so did everything this Court has required to exercise the power of sale. That's the critical distinction between this case and Pinty, and it should end the Court's analysis. In Pinty—
May I ask you a question, since I'm a simple soul? The American Bankers Association amicus says this isn't so complicated. There is a Massachusetts regulation which obliges the lender to send this particular notice, which tells the borrower that you can still avoid foreclosure by paying the total past due amount before foreclosure sale takes place. The total due past amount is set forth in that notice. Does that not mean that applicable law says that if that person hands over the past due amount before foreclosure, the bank is obligated under applicable law to accept it?
I think that's exactly right, and certainly that's Chase's practice here, and as reflected in other amicus briefs, that's the practice industry-wide. If someone is prepared to tender the amount to reinstate a loan, the lender has no reason to foreclose on the home.
Well, it's not a matter whether or not it has reason. I'm saying that the applicable law would obligate you. You were arguing that, oh, you're good fellows and you would, as a matter of grace, do it. The American Bankers Association, at least as I read it, says it's not a matter of grace. Under applicable law, you have told the lender, pursuant to this required notice, that he or she may do it, and if he or she does it, then foreclosure is avoided, and therefore applicable law obliges you to do it.
I don't disagree with that. And I think my only point is that practice is consistent with it. It's not like there are reports of lenders evading the obligation as reflected in the 5604 notice. This is industry-wide practice. And so however the Court wants to reach the conclusion that this wasn't inaccurate or deceptive, if it agrees that that's the legal standard, and I dispute that it is, there's nothing deceptive about telling someone that they have a right that they in fact have.
So if we declare that their applicable law is that you can hand over the money before foreclosure and that will forgive you, well, that will not forgive you, but that will mean that the foreclosure will not happen, then there is no deception in the notice because the notice is a reflection of what, in fact, applicable law requires, even though it's more than what the contract, the mortgage provides.
I don't think it's necessarily more than what the mortgage provides. So I agree with the premise of your question.
The mortgage may allow you to do it.
Exactly.
But does not, but the applicable law would oblige you to do it, require you to do it.
That's precisely right, Your Honor. I do think, however, just to take a step back to the legal question, the way the First Circuit panel interpreted this Court's decision in Pinty, there's a broad prohibition on saying anything that's inaccurate or deceptive in your foreclosure-related notices, notwithstanding your—
But is the disconnect in the 5 days window?
I'm not sure I understand the question.
Disconnect between the regulation and the mortgage?
Yeah, I think that's exactly right. What the First Circuit perceived to be in tension was the disclosure in the 5-day notice that says that you can still avoid foreclosure by paying the total past due amount before a foreclosure sale takes place, and you're right under paragraph 19 of the mortgage, to reinstate your loan up until the earliest of the 5 days before. Paragraph 12 of the mortgage, and I think this is what Chief Justice Gantz was alluding to, does allow the lender to extend the time for repayment, and as a matter of practice, Chase and other lenders do in fact do that. But to return to the question of Penty, because on a certified question to this court, I think it's implicit in the First Circuit's ruling that there's at least a lack of clarity on this question. Penty requires that a lender, before exercising the power of sale, make required and accurate disclosures. And I think there's no dispute in this case that what Chase provided pursuant to paragraph 22 was both required and accurate. It was required to disclose the existence of the right to reinstate. And I think it's important in this connection to make two observations. The first one is the right to reinstate is in fact conditional, as paragraph 19 makes clear. There are conditions imposed on it. Paragraph 22 nonetheless requires you to tell them that they have the right to reinstate. So Chase did that here. It told them that they had the right to reinstate, notwithstanding that there were certain conditions on that. And I think the other thing to observe in this connection is,
I mean, if you don't want to accept, or if you're reluctant to accept the notion that you were obligated as a matter of law to accept it, and we're stuck with, you want to pursue the Penty argument, doesn't notice of the right to reinstate also require that it be an accurate reflection of the right to reinstate? Which the notice was not.
So to be clear, I'm very happy to live with the first.
You're prepared to win on that ground?
Yeah,
as
I'm
opposed
prepared to win on
ground
that grounds. But with respect to your question, I dispute the premise in the following two ways. The first one is paragraph 22 requires you to disclose the existence of the right to reinstate, notwithstanding the existence of conditions on that right to reinstate in paragraph 19. I would contrast the detail in paragraph 22 on the notice of the right to cure. If you look at the first sentence of paragraph 22, it lists certain things you need to include in the right to cure. The amount of the default, the existence of the default, the date. Later in paragraph 22, all it says is you need to disclose the right to reinstate. Notwithstanding that there are conditions on the right to reinstate that aren't subject to any notice requirement, they're just listed in paragraph 19. What Penty and what the strict compliance regime require you to do is to disclose the information that's required by paragraph 22, telling a customer that they have the right to reinstate when a customer is obligated to read a contract and understand that there are conditions on it, obligates them to look elsewhere for the conditions on the right to reinstate. The state-mandated notice that Chase is obligated to provide doesn't undermine your right to reinstate in any way. It states a true condition that you can reinstate up until the date of the foreclosure.
The problem I have with your argument is that, okay, so your notice says you have the right to reinstate, and then it goes on to say, and you can reinstate it by, say, giving the lender $1 on the morning of foreclosure, and that will suffice, when in fact, that's just plain wrong.
So I think there are circumstances where, notwithstanding having disclosed the right to reinstate under paragraph 22, you can make a separate disclosure that vitiates your compliance with paragraph 22. That's not what happened here.
Isn't that what the First Circuit effectively found, is that the notice, which again, you were obliged to give by the Department of Banks, basically says you can, at the time of, you can on the morning of foreclosure say, here's the past amount due, and that is enough to avoid foreclosure, when in fact you could say, sorry, you should have done this 5 days ago, when in fact you have not. Doesn't that undercut the purpose behind giving the notice if we allow the notice to be potentially deceptive?
I don't think potentially deceptive is the standard. And again, I'm not disputing the initial premise of your question. I don't think the standard is potentially deceptive. The court has never held that in the context of a Section 21 case. Focusing on the strict compliance regime.
Before you leave that point, you've read the Abstract Club's amicus brief, right?
Correct.
And they say, okay, let's not confuse things any more than they already are. What's required by Penty is the paragraph 22, and that was done here, end of story. Should that be, because this is a group that deals with this as a societal-wide problem. Should we stick with, is that brief?
Absolutely. I think that's exactly right. And what I was about to say is Section 21 strict compliance regime, this court in all of its decisions dealing with the strict compliance regime has been exquisitely attentive to the implications of these rules on bona fide third-party purchasers, the title industry, and anyone who has an interest in real property. And part of the issue that this court has focused on is the administrability of a rule that requires strict compliance. Requiring, and this was part of the discussion between the majority and the dissent in Pinty, requiring that someone comply with the terms of paragraph 22, a party could discern that from the face of records that are recorded if they look at the notice and the terms of paragraph 22. It's easy enough to look at those two things side by side and say, this was compliant, therefore the mortgage is not subject to a voidness challenge later on. Saying that there's a potentially deceptive standard that is broad-reaching, and as the First Circuit articulated it, requires you to abstain from saying anything that could potentially be deceptive or inaccurate, not tethered to any matter that's related to the exercise of the power of sale, but anything. There's no way for someone looking at records that are recorded with the county assessor's office to figure out whether there's anything potentially deceptive. So the strict compliance regime makes sense in order to ensure that parties that are non-judicially going to foreclose are actually complying with their obligations, both statutory and contractual, but it has limits, and I think the limits are attentive to the needs of third-party bona fide purchasers and the real risks that the regime imposes on them when they've taken a property in good faith, and also requires some attention to how administrable the rule is. Can you figure out, by looking at the face of documents, whether this has been complied with or not? And I think, again, to go back to the Pinty rule, the issue in Pinty is that what Emigrant told the borrower was the exact opposite of what paragraph 22 required. Paragraph 22 required the lender to tell you that you have the right to bring an action to challenge your default. And what the disclosure at issue in Pinty said was, you have the right not to do that. You can lay in wait, and you could assert this as a defense. There's never going to be an opportunity to do that because this is a non-judicial foreclosure. And so the right that was required to be disclosed in paragraph 22 was never disclosed in Pinty. And to give another example, in American, the right that was required to be disclosed in American was the right that's at issue here, the right to reinstate. And this court held that telling someone, contrary to paragraph 22, which says you do have the right to reinstate, that you may have the right to reinstate, simply misstates that right. And that's why the court in American agreed that that was a violation of paragraph 22. That's not what happened here.
But it's not, I mean, from the point of view of the abstract club, all that the First Circuit effectively said was that paragraph 22 says you have a right to reinstate. Paragraph 19 says here's how you reinstate. And if you were to mischaracterize how you can reinstate, that could be a violation of Pinty. But the people reviewing it would have paragraph 22 and paragraph 19 and the notice. So all that would be required is they would need to look not only at the fact that you have a right to reinstate, but also to make sure that the manner in which you reinstate is also accurately reflected.
I think that's correct. But number one, paragraph 19, as even the First Circuit agreed, doesn't require notice. I mean, paragraph 19 is a substantive enumeration of the conditions for exercise of the right to reinstate. And again, I just remind the court that paragraph 22 doesn't require any enumeration of those conditions. It says you have the right to reinstate. Paragraph 22 does require the enumeration of conditions to cure the default, and that is a meaningful distinction, particularly in a strict compliance regime. Again, I do think, to go to Justice Kafker's point, you want to be able to have a regime in which bona fide third-party purchasers all the way down the line are able to figure out, looking at recorded documents, whether there's been compliance here. And their focus is going to be on paragraph, in light of Pinty, their focus is going to be on paragraph 22, what paragraph 22 and the given mortgage says. And again, the GSE mortgage is used in something upwards of 70% or 90% of those mortgages. You want to be able to compare the notice to paragraph 22. With respect to the GSE mortgage and their proliferate use in the state, I would just go back to Chief Justice Gantz's first point. This is a DOB promulgated notice, and certainly DOB didn't view there to be any inconsistency or anything potentially deceptive about requiring lenders to make this disclosure in view of the GSE mortgage, which as a form matter includes this provision saying that you have up until 5 days or the earliest of applicable law. And so I think the two notices, there's no inconsistency that a reasonable borrower would perceive between them, looking at the mortgage and looking at all of the terms of the mortgage, or looking at the notice and then looking at all of the terms of the mortgage.
Well, there is a difference unless you accept the view that applicable law requires you to accept it upon payment.
Certainly, or, I mean, as a matter of practice, the fact of the matter is no one's ever going to be potentially deceived in a way that harms them because they are always going to have the ability to reinstate the mortgage up until the date of sale. And whether that's as a function of the applicable law provision or as a matter of practice, I don't think makes a difference here because, again, in order for someone to be deceived or even potentially be deceived, there needs to be something that redounds to their detriment, and there's nothing in the record to suggest that that's so.
Okay, thank you.
Thank you, Your Honor.
Mr. is it Dion or Dion?
Dion, Your Honor,
Dion,
thank you.
Mr. Dion, good morning.
May it please the Court, Attorney Todd Dion on behalf of the appellee, the Honorable Chief Justice, and the Honorable Associate Justices of the Supreme Judicial Court of the Commonwealth of Massachusetts, good morning. It is an honor to present this case before this honorable court today, as not only have I been reading the same paragraph within the same mortgage for the last 5 years, but I've also been reading and closely
Groundhog
following
Day.
the words and the interpretations of this honorable court regarding that one paragraph for the last 5 years as well. While there are many jurisdictions in the United States that have followed the tenet that a mortgagee must strictly comply with the terms of this mortgage, from the Supreme Court of Alabama to the Supreme Court of Hawaii, and many jurisdictions in between, including Illinois, Minnesota, and Rhode Island, it is this honorable court that has, I must say, led the way and is ahead of these other jurisdictions regarding the application and the meaning of strict compliance as it specifically relates to paragraph 22 of this mortgage. Therefore, I respectfully look to this honorable court's guidance regarding this unique and esoteric issue under Massachusetts law and perhaps further explain the meaning of strict compliance with the terms of this mortgage. The words of this court in the landmark Pinty case indicated that the standard of strict compliance demands that a paragraph 22 notice must not potentially mislead a homeowner into sitting on his or her unequivocal rights under the terms of the mortgage. Otherwise, it's just a mere irregularity, was the word of the Chase decision that was cited by the Pinty case. So the notice must not contain inaccurate statements, and the inaccurate statements must not be just a mere irregularity. Now, while Chase argues that avoiding the potential to mislead is not a specific element of the Massachusetts statutory power of sale, it is certainly a requirement of the standard of strict compliance that any variation from or additional language in the paragraph 22 notice not conflict with an unequivocal right outlined in paragraph 22 that could lead to the disastrous consequence of foreclosure.
Let me ask you the question I asked your brother. If we were to say that the Department of Banks requires this notice to be sent, and requires that it be sent in precisely the language established in the regulation, and that language declares that, quote, you can still avoid foreclosure by paying the total past due amount before a foreclosure sale takes place. And if we say, well, that is now the law of Massachusetts pursuant to this regulation, where is there any deception?
Well,
And
that
where
language
is there any risk of a disaster? Because indeed, they would be obligated to accept that money, and you could avoid foreclosure if you were to do that, despite what the mortgage may say.
Well, Your Honor, first of all, that language is not required to be in a paragraph 22 notice. It's required to be in a 35A notice, which this court has been clear that these are two separate types of notices with different requirements and definitely different consequences for noncompliance. I don't think the language in the regulation is strong enough to extend an unequivocal right to reinstate the mortgage until the foreclosure sale, which I would argue they can't do anyway. How are they going to provide a right?
Who's the you and you can't do it, or they can't do it?
The Chase cannot extend a right to reinstate and pay less than the accelerated amount to any time before the foreclosure sale because the whole purpose of foreclosure to begin with is to collect the entire accelerated amount. If they were to say, well, the homeowner has a right to pay less than the accelerated amount at any time before the foreclosure, I think that would defeat the purpose of accelerating the loan to begin with.
Okay, so what do we do with the fact that the Department of Banks requires them to send this letter and requires them to send this letter with the language that they use?
Well, it doesn't require them to send it in a paragraph 22 letter. Chase elected to draft this so-called hybrid 35A paragraph 22 letter, and when they did that, they bore the risk of it being evaluated under a standard of strict compliance. And with that being said, they could have looked at the notice and say, well, this language conflicts with the unequivocal right or deadline to reinstate the mortgage pursuant to paragraph 19 and add a few sentences to fix the problem. In fact, especially in light of the fact that I believe there has to be a deadline on the right to reinstate, otherwise the loan cannot be fully accelerated and they can't foreclose on the entire accelerated amount rather than some partial reinstatement amount.
But doesn't Section 5604 require them to give this precise notice?
It does require them to give the notice in a 35A letter.
Say, well, that's not accurate, we don't plan to give it. Would the Department of Banks not be unhappy with them?
Well, it's not their
It
choice.
says the
I'm sorry,
mortgagee must provide a 90-day right to cure notice to the borrower in accordance at least 90 days. And it shall, and I think it says it has to use exactly with the language that has to give this notice, right?
They don't have a choice to include that language in a 35A letter, correct. However, they did have a choice. Right below that sentence, there is a fill-in-the-blank section where they have to input the total amount due and a date by which that may be paid to avoid eviction and foreclosure. At that point, they chose, rather than distinguish between the possibilities of what total past due amount could mean, they chose to input the pre-acceleration default amount, and they chose to also, the five-day limitation on the mortgage, they didn't comply with that when they filled in the date as well. So that was their choice, to fill in those blanks, and they inaccurately filled in those blanks in light of the language of paragraph 19.
And if your client had paid that amount, even though it might have been less than otherwise required by the mortgage, are you saying they could still have foreclosed?
They no longer have a right to reinstate after acceleration, so Chase very well could have said, sorry, this is not the full accelerated amount pursuant to the terms of your mortgage. That language in the regulation, it doesn't even mention a right to reinstate after acceleration. It doesn't, furthermore, it says the homeowner can avoid foreclosure by paying the total past due amount. That's not specific enough. I mean, I can proclaim that I can walk down Commonwealth Avenue today, but that doesn't mean that I have to. Just like Chase can proclaim
It
that.
also says you must, on the first page of it, you must pay the past due amount of, and you fill in the payable amount. So the payable amount is included in this notice.
Yes, and it is the pre-acceleration default amount that was filled in, which I believe is also misleading because it's not acknowledging that that amount could change dramatically after the supposed acceleration and definitely within 5 days of the sale when the entire amount is due. I mean, it's a difference of hundreds of thousands. So I do believe that they should have looked at this notice and figured out, gee, since this is being examined under a standard of strict compliance, we should acknowledge the terms of the mortgage, which dramatically change the balance.
In your view, any of these kinds of mathematical errors would also be Pinty violations? I'm just trying to get a sense of what, again, I'm concerned that Pinty is setting up, it's requiring strict compliance with something, but it seems like you're trying to sweep in a lot more, and that raises all kinds of concerns, given that this is standard verbiage in an industry which we've already unsettled a couple of times.
if they were going to, if Chase,
No, but the particular question, any mathematical errors are now Pinty violations too, in your view?
no, any false statements. This is a false statement to say that they can accept less than the accelerated amount any time before the foreclosure sale, because they have to accelerate the whole amount. They're not going to foreclose on half of a mortgage. They need to.
So if they get $10 wrong, is that, that's also going to be a Pinty violation?
If it puts the homeowner in a position.
If they say the
where-
homeowner owns $247,000.33, and it's actually 68 cents, are we gonna, is that also a Pinty violation now?
Well, if it could lead them to the disastrous consequence of foreclosure because it's inaccurate, then yes.
Isn't that a problem? If that's what Pinty meant, we better fix Pinty.
Well, the homeowner has a right.
Got to be some substance to it as opposed to, technical compliance that doesn't make any difference. Pinty's got to have a meaningful parameter, doesn't it?
Yes, it does, and I believe in this case.
But in your case, it's anything inaccurate is a Pinty violation.
It's not just an inaccuracy, it also involves an unequivocal right that guarantees the homeowner a right to challenge the foreclosure. Before 5 days before the sale, they're guaranteed a right to reinstate the mortgage, so if Chase says, no, we're not going to reinstate the mortgage, they can void the foreclosure. After 5 days, they no longer have that right, and I believe it's an important right that must be paid attention to. If after 5 days, if Chase refuses, they have no more recourse. They can't void the foreclosure if Chase refuses to accept less than the accelerated amount, which, the way I'm looking at the language of this mortgage, they very well can. So that puts the homeowner in a bad position. Also, I would argue, I mentioned the language below, the language in question, where they were to input the total past due amount and the date. 35A itself requires a statement in the notice that they have a right to redeem the mortgage and a date by which the past due amount should be paid. I think that's inaccurate as well, because they're not acknowledging the paragraph 19 conditions of the mortgage, the 5 days, and that they have a right to reinstate the mortgage prior to 5 days. And
I guess one
yes.
a problem I have with your theory is that if the mortgage says they don't need to collect, that you've got to pay the amount due 5 days before foreclosure, and the bank sends a notice that says you can pay it any time before foreclosure, and the bank indeed will accept that at any time before foreclosure, why is that deceptive? It's a departure from the mortgage, but it's a departure to the disadvantage of the lender. And under your theory, any time the lender would cut a break in the notice and give more time to the borrower, that would be a Pinty violation.
Well, there has to be a deadline on the right to reinstate. Otherwise, there is not a true acceleration. So I don't care if it's 5 days or 5 seconds before the foreclosure. At some point, they have to say, okay, we are demanding the full accelerated amount without allowing the homeowner a right to pay less than the accelerated amount. So I believe at any point, if the hypothetical homeowner could, 5 seconds before the foreclosure, tender the amount, Chase could refuse, and they would be misled by this notice into doing that.
That assumes they could refuse.
I'm sorry, Your Honor?
Your argument is premised on the view that Chase could refuse to do what the notice says
Yes,
can be done.
I would argue that they, in fact, have to, at some point before the foreclosure, they have to demand the full accelerated amount and not say that the homeowner has a right to pay less than the accelerated amount at some point before the foreclosure if they're going to accurately foreclose on the full amount.
Okay, thank you.
Thank you, Your Honor.
Mr. Chief Justice, may I request leave to file a post-argument letter?
Sure.
Okay, thank you.
As long as you give notice to the other side,
Absolutely.
Does that mean I would have a?
you would have an equal right to respond.
Okay.
But
Thank you.
I would encourage brevity, which is the soul of wit in these matters.
Thank you, Your Honor.